Next, I want to welcome Greg Baylor. Greg is the director of the Center for Religious Schools at Alliance Defending Freedom. He also serves as the senior counsel for government affairs at ADF, focusing on Congress and federal agencies. He's a graduate of Dartmouth College and of Duke's Law School. Greg is going to play kind of cleanup batter, I guess, here, because he's going to fill in anything that remains to be said, with a particular focus on some of the stories, real life individuals who have been harmed by these sorts of laws in other states where they've been passed. ADF is a wonderful law firm that has been representing many individuals who have been victimized by these sorts of policies. And so I'm just gonna turn it over to Greg to share some of those thoughts with us.
Great. Well, thank you, Ryan. And I also want to extend my gratitude to the organizers of this really important event. It's honestly quite a privilege to have been invited to participate. I also wanted to thank all the other speakers for their wonderful and informative presentations. You know, throughout the presentations, we've been hearing about the negative impacts that the Equality Act will inflict upon the American people if that bill becomes law. And one of the reasons we don't need to speculate about what the Equality Act would do is because lots of jurisdictions at the state level, the local level, and the school district level have adopted policies similar to the Equality Act, similar in how they ban gender identity and sexual orientation non-discrimination, and how they neglect to adequately account for those who dissent from the emerging sexual orthodoxy. I'd like to share some of the stories that have come about because of the existence of such policies and laws at the state and local levels. Alliance Defending Freedom, my organization, not only attempts to influence members of Congress and their staffs about things like the Equality Act, we also have the great privilege of representing clients in litigation. So although I didn't personally represent very many of these individuals and organizations, it is firsthand information about the harms that will come about if we have something like the Equality Act at the federal level. ADF represents a nonprofit religious organization called the Downtown Hope Center in Anchorage, Alaska. This is an organization that helps the homeless, feeds the homeless, teaches the homeless, and its services are open to both men and women throughout the day. At nighttime, however, the Downtown Hope Center does create a safe space for women and only women to sleep. Many of those who are housed at the Downtown Hope Center overnight are women who've been victims of domestic violence, other abuse, or trafficking. So you can understand why, given its limited space and given the need in the community, the Downtown Hope Center decided to reserve its communal sleeping space just for women. One night in Anchorage, a man who identifies as a woman appeared at the front door of the Downtown Hope Center. He was intoxicated, he was injured and bleeding, and he asked to sleep overnight in the Downtown Hope Center. Now, they didn't just turn him away, they responded in compassion, and they offered to take him to a hospital for treatment. They offered to transport him to a men's shelter where he could comfortably stay. And he declined both of those things. What he did instead was to go to the city of Anchorage and essentially file a lawsuit or file a complaint against the Downtown Hope Center. Under what law did he do this? Well, he did it under a law that's similar to the Equality Act. The Equality Act, if it passes, would outlaw sexual orientation, gender identity, discrimination in, quote, places of public accommodation. As Robert Vega from USCCB mentioned in his presentation, one of the things the Equality Act does is to dramatically expand the definition of what counts as a place of public accommodation. And I guess Anchorage's definition of that term was broad enough in its ordinance to reach, at least they thought, a shelter like the Downtown Hope Center. So he claimed he was discriminated on the basis of gender identity because the shelter reserves its communal sleeping space for biological men. In the course of defending Downtown Hope Center in this case, it came out that the feelings of the women who were staying there. And one of them remarked, I thought quite poignantly, she said that if she were forced to sleep, and again, this is a communal space where the cots are 3, 4, 5 feet apart, that if she were forced to sleep in a space like that with biological males present, that she would rather sleep outside in the cold Alaska winter than to do that. So again, the Downtown Hope Center doesn't just serve women, but it reserves its sleeping space for women. Now, fortunately, they prevailed in their case. We were able to persuade the adjudicator that the Downtown Hope Center is not a so-called place of public accommodation. The problem is this: if the Equality Act passes, its definition of place of public accommodation is much broader. It explicitly includes shelters. There is an intent on the part of the drafters to reach nonprofit organizations, including food banks, on shelters. So the Downtown Hope Center would not be able to escape liability and prosecution under the Equality Act were it to become law. The other way that that scenario would be nationalized through the Equality Act is through the Equality Act's amendment to Title VI, which is that piece of the Civil Rights Act that attaches a non-discrimination string to federal financial assistance. Now, the Downtown Hope Center doesn't take federal money, but lots and lots of homeless shelters, gospel rescue missions, and the like do take federal money. And if the Equality Act becomes law, they would become subject to a rule like the one that the Hope Center got in trouble with. Creative professionals. You've probably read in the news about the cases involving typically Christian creative professionals who come into conflict with a state law or an ordinance that forbids sexual orientation and gender identity discrimination. Again, if the Equality Act passes, this is something we're going to see proliferate and be magnified and be found all over the entire country. ADF has had the privilege of representing a handful of these creative professionals in their conflicts with these Equality Act-like ordinances. We represent Jack Phillips, who is a cake artist in the Denver area of Colorado. He serves everyone, but he can't create every message. Everyone who walks through the door, he is willing to serve. But some people request custom cakes that communicate messages that celebrate events that he, as a matter of conscience, as a matter of his religious conviction, cannot be part of. Prior to the incident that led to his case, that led all the way to the Supreme Court, he had turned down business to create cakes that celebrated things that he was opposed to. He even turned down a cake that had an anti-LGBTQ message on it. But one day when someone came into his shop and asked him to create a cake that would be used to celebrate a same-sex wedding ceremony, he respectfully declined because of his conscience. And needless to say, there were countless other bakeries nearby that were willing to provide a suitable cake for the same-sex couple that wished to be married. In fact, the other bakery did it for free. But that wasn't enough. It became necessary in the eyes of some to go after Jack, to punish him, as it were, for his sin. And he was charged with committing sexual orientation discrimination under a state law that bans discrimination, again, in places of public accommodation. You may have heard that his case went all the way to the Supreme Court, and he prevailed. It was a relatively narrow basis. It was based on the animus of the adjudicators, the religious hostility and bigotry that they showed. The court said that he just didn't get a fair shake because of that. But the point of the story is we're going to see more and more of that if the Equality Act becomes law. Similar story out of Washington State. ADF represents Baronelle Stutzman, who runs and has run Arlene's Florist for many years. She had a lot of relationships with recurrent customers, including a man named Rob Ingersoll. For almost 10 years, she had been serving his needs. They had become friends over time, chatting every time he came into the store. She was aware that Rob identified as a gay man, and that made no difference to her whatsoever when she was either interacting with him as a friend or selling him flowers. for the various life events that he wanted flowers for. But he came in one day and he said that he was marrying his partner and he wanted Baronel to provide the flowers for the wedding service. And she told him that she couldn't do that because of her relationship with God. And he seemed to be very understanding about that and understood who she was and where she was coming from. And he probably understood that there would be plenty of other florists willing to help him celebrate his same-sex wedding. However, news of this encounter became public. The Attorney General of the state actually read about it on a social media post and decided, like Jack, that Baronel had to be punished. So he commenced litigation against her, and not only going after her business, but going after her and her personal assets as well. That case continues on. We've asserted First Amendment defenses, but I think Baronel would prefer if she hadn't been sued in the first place. And again, the problem with the Equality Act is that if it's passed, we'll have this sort of scenario, not just in some states like Colorado and Washington, but in many, many others. You know, the gender ideology is starting to creep its way into custody disputes, disputes about who should have care and possession, as it were, of children. Susan mentioned a case out of Ohio. I'm not going to say much more about it than she did, but there was a situation where there was a troubled young girl, and she was struggling with her gender identity. Her grandparents kind of got involved in the mix, and that at some point she ended up staying with them. They were very much in favor of treating her alleged gender dysphoria with cross-sex hormones and potentially surgery down the line, but her biological parents were not. They did not think that that was the best course of action for their daughter, both socially transitioning and as a matter of kind of good medical judgment. It's a complicated case, but it's definitely true that when the judge was making a decision about awarding more permanent custody to the grandparents, that the parents' unwillingness to consent to the provision of cross-sex hormones to their daughter played a role and undermined their position, undermined their ability to get their daughter back. And the Equality Act would not directly dictate this result, but it certainly, its mindset, its underlying ideology would point in that direction and probably encourage the proliferation of situations like that. A number of the presenters have mentioned the situation involving female athletes who are forced to compete against males who have, particularly following puberty, undeniable biological advantages. ADF represents a number of female high school athletes in the state of Connecticut. All of them are track runners. All of them are elite. All of them work very hard every day to shave hundreds and tenths of seconds off their personal bests because they want to compete, because they want to win, they want to advance, they want opportunities for scholarships. As these girls approached their junior and senior years in high school, there were two young men who began identifying as girls and started competing in their races. This was because the Connecticut Interscholastic Athletic Association said that it would be discriminatory to exclude boys who identify as girls. These boys did not do anything even to attempt to diminish the physiological advantages they have just from being male. These two boys alone have captured almost 20 state titles in Connecticut since they started competing in the girls category. They have robbed female athletes of approximately 85 opportunities to advance to higher level competition, including competition where scouts are attending, scouts from colleges who might be willing and able to afford them scholarships. We're continuing to litigate that case, but I think the Equality Act, again, would recreate this problem nationwide. As Robert mentioned, it's not so much because it amends Title IX, the statute that we think of when we think of women's athletics, but because it amends Title VI, which, like Title IX, is a non-discrimination string that attaches itself to federal money. So we can expect to see much, much more of that nationwide if the Equality Act becomes law. The last story I'd like to tell involves religious education. The state of Maryland has a school choice program, the Opportunity Scholarship Program. Like most school choice programs, it's focused on individuals with financial needs who come from disadvantaged circumstances, who customarily would not be able to afford a private school. And it customarily benefits students who are in public school districts that are underperforming. We represent Bethel Christian Ministries outside Baltimore, between Baltimore and Washington, D.C. They've been a participant in the scholarship program. They have never, not once, turned away an applicant for any so-called discriminatory reason, whether it's the religious convictions, the beliefs of them or their parents, whether there's sexual orientation or gender identity. And they told the state that they would not turn away students because they identified as homosexual or transgender. But nonetheless, simply because the school had in its policies a statement that it believes in the traditional understanding of marriage as one man and one woman, that it believes in the distinction between the sexes, that God created them male and female. For that reason alone, the state of Maryland not only withdrew their funding, but also demanded that they pay back over $100,000 in funds that they had already received. This is the sort of outcome that we will probably see under the Equality Act if it becomes law. First, it's possible, even probable, that schools will be deemed places of public accommodation. And I think it's important to understand that, because every time we say that, what we're saying is this entity that's deemed a place of public accommodation can be regulated even if it doesn't get money from the government. So you can't avoid these problems. We're saying, well, I'll just give up the federal financial assistance. I'll only accept students that don't have federal. No, that is not going to be a workaround to the problems that the Equality Act created. So again, the case is still in litigation and we're hoping for a successful outcome. But what I don't want to see is again, a repeat of this in every state in the union. Again, we don't need to speculate about what the Equality Act will do. We've seen what analogous laws at the state and local level do. And along with Gabby, I encourage you in the strongest terms possible to communicate your views about the Equality Act to your elected representatives in Washington.